LAWsome by Consultwebs. Breakthrough insights to build a thriving law firm with your host, Tanner Jones.
Hello, everyone. Today on the show, we're talking with Kelley Keller, the founder of Big Bang Legal. They prepare businesses to meet the digital age. Her practice focuses on a broad range of domestic and international intellectual property issues, technology transactions, and internet law. Kelley has been practicing for nearly 2 decades, working with IP matters, and has represented clients across a broad range of industries. Today's topic is how to reduce conflict with clients, a topic I think we've all dealt with in the past, or at least we're interested in this. So, Kelley, thank you so much for making time to join us on the show today.
Oh, my pleasure. I'm happy to be here.
Fantastic. Well, let's just dive right in. I mean, with 2 decades of experience working with IP matters in a wide range of industries, I would imagine that there's probably a theme to some of the conflicts or some of the issues that arise, and often driven largely by communication, possibly even a lack thereof. But based on your experience, what do you think are the most common situations that cause conflicts with clients?
Sure. So communication is a huge one. And everything I say here, I'm actually going to say because I've done it incorrectly or I've made the mistake. So I'm aware of what it does, and then I've had to own that and work on that. Sometimes, lack of communication is not necessarily something we were intending to do, but circumstances just made it so that we dropped the ball. But I want to go back to something you just said about working with a broad range of industries. Yes, there is a lot of conflict based on industry, which I'll get to in a second. But I want to step back and say, for me and my experience, it's been more on the size of the client and whether or not they have in-house counsel, or if they are really small or new, whether they've actually ever worked with an attorney beyond maybe a corporate formation or some startup documentation. And so a lot of it is, what is the knowledge level that the client is beginning with in terms of their intellectual property needs or the things that they're going to face while either, selling products and services online or advertising their products and services that they sell in a brick and mortar environment. So to me, when I first started my solo practice, it was 2010, and I remember I just come out of really big law. And so I really pride myself on being able to communicate things really clearly and really effectively. But what happened is I went from working in big law, where I was part of a team supporting, Fortune 50 and Fortune 100 companies. And our client, my client was my boss, and my boss's client was the in-house lawyer at said huge company, right? So I didn't really work with clients directly in the sense that when I started my own practice, all of a sudden I was working with business owners themselves. So I am speaking to them using all of the words that I would speak to another attorney with, because I didn't know anything different. And all of a sudden you're sort of sitting at the conference table and you just see this glazed look and you're like, what I have here is a failure to communicate. So for me, I think that one of the big issues in conflict is communication. And the second one is mismanagement of expectations. With respect to communication, it's not just the management of expectations, obviously, is about communication. But the other piece I found is, do they actually understand what's going on, what they need, and why they need it? Because if you're somebody that has never worked with a lawyer, or you don't have a parent or a sibling or a good friend who has been in practice, for many of my clients, they've never come in contact with a lawyer before. So it's a really kind of terrifying experience. So you really have to just relax and help them understand things using stories and analogies they would understand, so they have something that's relatable. Because while it's my vocabulary and my zone of genius, it's not theirs, and vice versa. their industry speak and their zone of genius isn't mine, so I would need them to do the same thing. So conflict arises primarily from not understanding the value of what the lawyer is bringing to the table and from mismanagement of expectations.
And you hit on the point about, it often takes mistakes and more often the tough, painful mistakes that teach us the best lessons in life. I think that's so true for any business owner, for any lawyer. But naturally, it's always better to learn from someone else's mistakes when that's possible, right?
Yes. Regrettably, I've had the opposite. I've learned primarily from my own, but that's okay.
But you're here today on the LAWsome Show to hopefully save countless time and hours and conflict for other lawyers who are listening in and looking to learn from you here, Kelley. But I would ask you, naturally, disagreements are going to come up in business. Conflict will arise in operating a business. But in terms of the ideal way to possibly prevent those types of situations, to avoid conflict, can you give our audience members any steps to avoid disagreements or mishaps with clients that you've learned?
Absolutely. I'll tell you from my own experience is this. When you begin an attorney-client relationship, you both come to the table with a certain set of assumptions. And the first thing you need to do is make sure that you're both operating from the same assumptions, that you're at a starting point. So it's articulating, here's where we are. This is what I understand your situation to be. Here's where I'm coming from, and this is what I understand your goal is for what you want. What are the outcomes that you're looking to achieve as a result of this engagement? And it's the lawyer's responsibility to mirror that back to the client and articulate it to them so they can hear it and make sure they agree. Lawyers make what I believe is an unforced error by assuming the clients know what they need. They don't know what they need. They know what they're afraid of. They know what they fear, and they know what they don't want to have happen. They don't know how to fix it, else they wouldn't be talking to you. So it's important to assume that the client has a bona fide fear and that they are vulnerable talking to you because they're so far outside of their zone of genius and expertise that they feel it's really easy to be taken advantage of. So you need to dive in and make sure that you are getting clear on what they're assuming, what they understand to be sort of the reality, and that you lay the baseline so that you're at the same starting point. That is the very first thing that you should do. The second thing then is to make promises that you can actually deliver on. This is really hard, especially when you're a younger attorney, because you have no idea how long things are going to take until you're in the middle of them. And here's why. Legal services is not a one-way transaction. We misunderstand it to be that. So we assume that the lawyer is delivering a service to the client. No, the lawyer is helping a client solve a problem. But in every situation, there are what I call good facts and bad facts. The lawyer needs all the facts, but the chances a client will disclose all of the facts in your first meeting are very small for two reasons. One is they may not realize it was like a relevant fact or a salient fact. And two is who wants to be sort of raw and vulnerable in front of somebody they don't know. So learning how to let the client feel safe in the disclosure is more art than science, and it's less about lawyering and more about interpersonal relationships. So the best way to avoid conflict, obviously, is to anticipate it and address those challenges up front. So we want to find the starting point, and then we want to make sure that they feel safe and will disclose everything to you, because, a chain is only as strong as its weakest link. And the lawyer needs to know where we have a vulnerability so they can protect you against it. Because when I'm representing a client, if I'm advocating for them in a negotiation, I want to know where the other side is going to try to take advantage of my client. So I'm prepared to put up a wall there so they can't penetrate it, or at least do everything I can to make it really hard for them to do it. The third thing that you need to do is to be crystal clear in your fee agreement on what you're charging for, how much you're charging, what deliverables they are going to get in exchange for that, and when they can expect to receive them. There are three ways really that lawyers will charge. One is billable hours. The other is a flat fee. And then the third one would be like a contingency fee, a percentage of recovery. So let's talk about, for example, a flat fee. I know this because I did it wrong forever. Is you say, the client's like, okay, I need a joint venture agreement. So you're like, here is my quote for a joint venture agreement. It's a flat rate. You're going to get your joint venture agreement. You start to have the conversations with the client and you realize they don't need a joint venture agreement. They don't need it at all. They need something else. So what's important is, as soon as you realize that whatever scope of work you've outlined is no longer practical and you need to modify the scope of work or even the fee, you need to articulate it, stop, get it in writing, and find the starting point. Anytime there's a change, you want to find the starting point so everybody is on the same page. Because what will happen is this: the client has an expectation that they're going to get a joint venture agreement. You realize through 7 conversations that that's not what they need at all. But at the end of it, they're like, I didn't get my joint venture agreement, so you don't deserve to be paid because that's what you said I was giving you. So I mentioned that to say this: if the strategy or the consultation call is the service, that's the deliverable. If it is a document to document a relationship of the parties, whatever that is, that's the deliverable. You need to then say, when I'm going to give you the deliverable, we're going to have up to 3 hours of consultation time. If we move beyond that, then we're going to charge more. I'll let you know. But it's really, really clear so the client understands, what are they buying? Are they buying time? Or are they buying documents, or both? And I have found in my practice that failure to be really clear on that and to then step in when there's a modification or an amendment or some type of change that we need to document, not getting in there and stopping and relying on the phone conversation and memory, which is really faulty. Even, really, they can be reasonable about it, but assuming that the client understands the modification and that they're not going to get the agreement, and here's why, but they still owe you the money, that is so important. And that is probably one of the most important pieces of advice I can give to anybody practicing law, especially if you're up and coming. You can never be too clear, and you can never go wrong with clarity and efficiency and restating back to the client, do you understand? Do you have any questions? So crystal clear.
And the formula you use is it's simple and it's practical. The idea is basically, if you're having to recalibrate the relationship, as you said, a changing goal, a changing situation with the client, whatever it may be, looping right back to step 1 on the alignment piece and ensuring that you're realigned with that. That's the communication piece, and that's what I'm hearing. And I think it's simple yet extremely practical to implement in day-to-day communications with clients.
And a simple email is fine. Just want it, per our conversation, are we on the same page? Yes. Great. Put it in your fee agreement. Put it in the file, whether it's electronic, wherever it is, in a manila folder, who cares? That way you're just seeing, it doesn't have to be this big formal process, but it's an exchange with the client with an acknowledgement that we've made a shift.
Makes sense. I'd like to take a slightly different direction. I mean, still leaning on the concept of learning from mistakes, and they say hindsight's 20/20, and if only we could just prevent problems before they occur, we'd all be in much better shape, supposedly. But in the direction of hiring lawyers, so some of our listeners, a lot of firms are in growth mode right now. We're seeing a lot of lawyers bouncing from one firm to the next right now, it seems, as well. And so this is a common topic. And I'm curious about the concept of digging into potential hires of lawyers before hiring them in an effort to avoid potential conflict issues. Have you explored that area in operating your own business? And what advice would you give to our listeners in that respect?
Sure. So there's a couple of different angles for this. When we think about conflict, lawyers are immediately going to say, do I have a conflict in the sense that if I represent this client, are they a competitor of another client? Do I have a conflict? So for the client, they can ask the attorney, here are my key competitors. Do you work with them? Now, maybe the attorney doesn't have a conflict for purposes of ethical rules and responsibilities. That's a different standard than the preference of a client. Okay, so the first question is, do you work with any of my competitors in the sense that I won't be comfortable with you working with me? Now, an attorney is obligated not to disclose information, and I've never really met a lawyer who doesn't have extreme discretion. We're taught that from day one, and the attorney-client privilege is very sacred, and I've just never really seen that. But that's important for you, or to have the lawyer articulate why they will or will not be a good fit for you vis-a-vis that. The second piece is the lawyer routinely terminated by clients? So I don't think that is actually a fair litmus test, because there are a lot of reasons why attorney-client relationships end, but the lawyers are not at disposal, or they are not free to disclose why they ended. So whatever the client says publicly is the gospel truth, even though 99% of the time it's not really. A lot of times what will happen if a lawyer works with, so for example, really small companies. This has happened to me where I'm like their fourth lawyer. So as soon as they hire me, if we end up moving forward, I know I'm going to be their lawyer for a period of time, because then I'm going to be the fourth lawyer and somebody else is going to be their fifth lawyer, because that's their modus operandi. So I think that for lawyers, for clients who are looking for lawyers, do clients fire them or not isn't really the right inquiry, but more like, okay, have you worked with other clients who are similarly situated with me, either industry-wise or where we are in stage of business? I always like to look at things more from where you are in a stage of business, because your legal needs change. But are you experienced with this type of issue? And a lot of times the lawyer's testimonials will help with that, or other case studies. But I think it's really fair for a client to say, I'm not sure what I need, but this is what I want to have happen. And ask the lawyer to tell them how they will help them achieve that goal without actually giving legal advice. The lawyer will do that, but it is okay for the client to ask to be made comfortable before they move into the engagement. But a lawyer's relationship with another client, I do not believe is generally a good litmus test, because you have no idea what really happened inside that relationship. And just because it wasn't a good fit between that lawyer and that client doesn't mean it won't be a great fit with you. I mean, we are dealing with humans and personalities as well.
Those types of issues or disputes or whatever you want to call it, or they're going to arise. They are inevitable, as you said. We're human. That happens. I'm curious, any particular action a law firm or attorney should avoid?
You can never completely avoid conflict because at the end of the day, these are human beings. They're not unilateral, they're bilateral transactions, meaning there's not just one person, there's two. I mean, that's the difference between like a do-it-yourself service and working with an attorney. If you're doing it yourself, you're the lawyer and the client. You're the only one. So you're relying on your knowledge, your experience, and you're taking care of things on your own. So there's no conflict to have. But when you're dealing with someone else, for a lawyer, it's really important to have a standard for what type of client you'll work with and what type of client you won't, and then to stick by it. And I will tell you this, for me, again, lesson learned the hard way. Most conflicts that I have with clients are generally with those who are relatively new and may or may not be revenue positive. So if they're not well funded, then we end up having more challenges because they're not able to fully implement the legal strategy. They may not be ready. So it's important to make sure you kind of have this product market fit. So you don't want to give too much service to somebody who's not ready. Like we don't need to, use a sledgehammer with, a small nail to hang a picture. So you don't want to be in a position where you're over lawyering or under lawyering. So the best way to avoid conflict is to make sure that you are a good fit for filling the need, not filling the want.
Tremendous advice, finding that balance, knowing where your value is to the market and being okay with letting other clients go. I think that's a big mindset shift that has to happen for a lot of lawyers, is just being able to let go, prune, if you will. And that's wise. And on the financial side, that's natural in business. If you're overstretched as a business owner and you're working with a law firm and the finances aren't there to be able to cover what you've committed to doing, naturally that adds whole new layers of conflict and stressors that could have been avoided, just as you said, by making that decision in the beginning when you noticed it wasn't the ideal fit.
And I've done that as a lawyer. I've also done it as a client where I've overhired for something that I didn't need, but I was excited and I wanted to commit to it. So I've kind of seen it from both sides. But it's important to remember that you are not everybody's cup of tea, but you are somebody's cup of tea. And that's okay. It's not a rejection. It's just not a good fit. And that's okay. And, I got an email just the other day from somebody that I wanted to hire them as a service provider for me. We had a wonderful intake call. Everything was good to go. The next day, I got an email that they didn't think they were the best fit for me. And that's okay, because whatever my needs are, if they're not prepared to meet them, whether I'm not big enough, I'm too big, whatever that is, then it's good to know now, like, why get married when you know it's not working, right?
For you, as difficult as that may be to accept, there is, you still walk away with a level of respect that they were able to do that, knowing it. They were giving up potential business, giving up money, giving up opportunity for their own growth, all serving you in that process because they identified something that didn't align well.
Exactly. Now, I will say this as a piece of advice to attorneys. When you do that with a client, give them the respect of an explanation about why you don't believe you're a good fit. That was what bothered me in this situation, where I received an email that says, it was so wonderful to talk to you, da, 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 da. And at the end, I got the full offer. I got the price. I agreed to it. I was waiting on the contract. And then all of a sudden overnight, I wasn't a good fit. They didn't give me an explanation. And I asked for one and I wasn't given it. I can assume why I think I'm not a good fit. And that's okay. It's not a big deal, but give people their respect. If they've taken their time to disclose their problems to you, you're very vulnerable when you're working with lawyers and you're working with CPAs. I mean, law and taxes is not because everything is hunky-dory and happy. It's about preventing problems or solving problems. This is not like, going out to happy hour with your friends. There's nothing fun about it. We do our best to try. But I think that's also really good advice in the communication piece is help clients understand why you're not a good fit. I can always say to a client, you're too early. And you're not going to have a good return on your investment by working with me. The transaction fees to you to get help from me will exceed your return on investment of investing in this at this time. Let a client know that so they understand they're too early. And then give them a way they can bridge the gap. If you're always, when you're saying you're not a good fit, but give them something they can do as a next step so you're not just rejecting and then leaving them to wonder what's wrong with them. That engenders trust. And they may come back and be ready for you. They may not. And they may be ready and then go somewhere else. That's okay too. What comes around goes around.
And just as you said, I mean, you said you had an assumption. You were not given clear details as to why, but you immediately assume. And just as you did, you have to expect that every potential client you turn away as a law firm, if you do not give them clear reasoning as to why, they're going to assume. And what do we do as humans often? We assume the absolute worst. Yes. And so that's, again, you nailed it when you said it goes back to the communication piece, the alignment piece. All of that matters in this process to help avoid conflict.
It does. And I think the other thing it's important for clients and lawyers to really focus on, nobody likes conflict. Everybody's uncomfortable with conflict. And you need to be okay with things not being okay. We are very rigid in our society these days. It's very all or nothing. We are not as adept at compromise and learning to amble forward through a challenging situation and allowing it room to breathe and room to self-resolve. Not everything has to be fixed overnight. Not everything will be fixed overnight, and it's okay to remain in a space of discomfort for a period of time until you can manage through it. I remember specifically hearing this when President Trump won the 2016 election, and Ivanka Trump and Chelsea Clinton had been very close friends. But that obviously created a problem in their relationship. And I remember an interview with Ivanka Trump where they were saying, will you be calling Chelsea, whatever? And she said, this is a new phase, and I will reach out to her to see how we navigate going forward. I have no idea what happened, obviously. I just remembered that as an external event that had nothing to do with their friendship, put enormous pressure on the relationship and divided alliances and allegiances. And, obviously you're dealing with parents, etc. And so I remember hearing that, and I thought, it's a really mature way of working through things. And as lawyers and as clients, we need to know that it's okay if everything isn't perfect. Give it just breathe it out a little bit and be chill a little bit, and you'll usually find a resolution if you don't put too much pressure on it.
Hinting on this direction, but I would like to go ahead and take it there. We've talked a lot about, I guess, the negative of conflict. Obviously, there's negative in that, in what you deal with emotionally, physically, in the relationship itself. But it arguably doesn't always have to be that way. Dealing with disputes in a professional manner can create truly honest relationships, can bring people together even closer, even increase collaboration. What's your overall take on that, Kelley?
Yes. Thank you for that question. There's a couple things. There's two ways I'm going to answer that. One of my favorite ways to resolve dispute is to find a way for them to collaborate. So let's say that somebody is allegedly infringing on somebody else's trademark, but they're making a ton of money. So let's say I'm representing the trademark owner against the alleged infringer. So we would call my client the senior user and them the junior user. If they're making a lot of money, then it could be in my client's best interest to resolve that dispute through a license agreement so that they continue selling, but that my client gets a cut of the revenue. It's a win-win. And at the end of the day, the collaboration is in for the benefit of the consumer. You're getting more product or service out to the consumer, and I believe that a rising tide lifts all boats. So a lot of times, what also happens with conflict is that when we get the parties together and we start to peel back the onion, and we get the hurt feelings, and we get the insult quality sort of taken away, and we get to the heart of the dispute, that we realize they actually want the same thing. Neither knows how to get there, and they're so personally hurt that they need a third party neutral to help guide them to a more productive place. And so I find a lot of times that conflict is the catalyst for collaboration. It doesn't have to be the end of a relationship or the end of the world. But that requires both parties to be in good faith, wanting to move forward. I always say to my client, are you looking for progress or are you looking for punishment? If you're both looking for progress, we can get to a deal. If you're looking for punishment, you might as well stop now. You're never going to get there.
Yeah, I've really enjoyed the conversation. Anything in particular I haven't asked you that you would have wished I would have?
Well, I'm going to say something, but I don't think you would have asked this question. But I'm going to say one more thing about conflict, if that's okay. So I'm really interested in this topic, and there's a fantastic book by a woman named Sarah Schulman, and she wrote a book called Conflict is Not Abuse. It's a really intense, heavy read, but it's excellent if you're really interested in understanding about conflict. And she raises this issue of overstatements of harm. And I think this is the primary genesis of conflict. Whoever is the harmed party is overstating the harm that they actually received as a result of whatever the transgression was. So it's working for you was the worst decision of my entire life. You ruined me. No, it wasn't. And no, you're not ruined. You're mad, but you've overstated the harm. So what happens is that whoever the transgressor is, they can't ever be redeemed because they didn't do what they're being accused of doing. So when we think about conflict, whether it's from the lawyer perspective or from the client perspective, and I'm going to say this from the lawyer perspective primarily, it is your responsibility to understand what really happened, not what somebody said happened or how they feel about what happened. Because we're trying to fix a root cause, not treat an emotional symptom. We always want to get to fixing causes or we'll just have a repeat of the same thing. And that's a really tough, sensitive process. I find a lot of times with really small business clients that half of my work with them is managing their fear and their perception of harm that's blown way out of proportion. And I'm constantly like talking them off the ledge, bringing them off the ledge, because that's sort of that management of expectations. But always look for the overstatement of harm so that you can kind of get past that and get right underneath. Because when you start talking about what the real problem is, that outer stuff starts to kind of dilute or dissipate, and then you can get to the real problem. I've never been unsuccessful in a dispute resolution when we have a bona fide problem about progress, but I'm never successful if the goal is punishment.
Thank you so much, Kelley. What's the best way for someone to reach out to you?
I'm a big person on LinkedIn, so please hit me up on LinkedIn or send me an email to Kelley@bigbanglegal.com, Kelley at bigbanglegal.com. Shoot me an email, but definitely connect with me on LinkedIn. Shoot me a DM and say that you watched this show. I'm really responsive there. It's probably the best way to get me. I get a lot of email, but those are the two best ways.
LAWsome by Consultwebs with Tanner Jones. For show notes, links, and info, go to consultwebs.com/podcast. Be sure to subscribe and leave us a review. Watch for the next LAWsome episode to discover more breakthrough insights to build a thriving law firm.